welcome to the Play Talk Podcast. I'm Rob Port. We got a great show coming up. Later in the podcast, we're going to be talking with State Representative Karla Rose Hanson. She is a Democrat from Fargo. She is proposing legislation, and it's bipartisan legislation. The Republican Senate Majority Leader, Rich Wardner, is a co-sponsor of this legislation. But what it is it's essentially gun control. It would create. They've been describing the legislation as red flag legislation in other states. But essentially what it do is it would set up a process whereby law enforcement or family or household members could seize guns away from somebody who is adjudicated in a court of law to be a danger to themselves or a danger to others. It's an interesting legislative proposal. I'll be honest with you, and you'll hear during the interview, I'm a little skeptical of it, mostly from the perspective of pre-crime. While I certainly don't want people to be committing suicide, and while I certainly don't want people to be committing crimes with guns or hurting other people with guns, I worry about a situation or giving the government the ability to take away somebody's civil right, to deny them their civil right, which the Second Amendment is. It's a civil right to keep and bear arms, to take that away from them before they've actually done anything. And in fact, to me, and you'll hear me cite this example during the interview, it smacks of what in the free speech arena, the First Amendment arena, we would describe as prior restraint, which is the government censoring somebody before they speak because of what the government is afraid will happen if they're allowed to speak. I think what we're doing in these instances is we could be taking guns away from people because of what we're afraid they might do. And while maybe in a given situation, you could look at a given person and you could say, well, that's reasonable. It certainly looks like this person is dangerous or is going to do dangerous things. I think that's a slippery slope to walk on when we start saying, well, we're going to deny you rights because of what we think you might do. So anyway, well, it's an interesting debate, and it's going to be a hot one down in the legislature, and you'll certainly hear that interview with Karla Rose Hanson here in a little bit. But before we get to that, a couple things from SayAnythingBlog.com, North Dakota's most popular political blog, I wanted to talk with you about. One of which is Marsy's Law. Now, you guys will remember Marsy's Law. It's from the 2016 election cycle. I think Marsy's Law is yet another example of why the initiated measure process is deeply, deeply flawed and a poor way to make public policy. Marsy's Law was bankrolled by a California billionaire by the name of Henry Nicholas. It was named after his sister, whose name was Marsy, who was murdered. The legislation, the constitutional amendment, and it passed, and it's in our state constitution now, it purports to be about victims' rights. But it's not really about victims' rights. Well, I guess I shouldn't even say that. I shouldn't say it's not about victims' rights. It is about victims' rights. The problem is that it's also what myself and many others opponents, critics believe is a subversion of the constitutional protections for the accused. Now, this has manifested itself in a number of ways. For instance, right now, one of the most notorious ways that Marsy's Law has been used so far in North Dakota is by law enforcement officials who are invoking Marsy's Law as a way to keep their names out of the papers when they're involved in a shooting. So when a law enforcement officer, rightly or wrongly, uses force against a member of the public, law enforcement is now invoking Marsy's Law as a way to block transparency efforts so that the public is aware of who the officer was who did that. That's one way in which Marsy's Law is being used. There's a lot of other problems, but a recent example went all the way to the North Dakota State Supreme Court. It's a case called State versus Strom, and it's about a woman named Melinda Strom who was convicted of embezzling from a drilling company she worked for and was ordered by the court to pay back over $690,000 in restitution. Now, she appealed that order because in the North Dakota Century Code, there is a statute which says that court-ordered restitution, I quote, may not exceed an amount the defendant can or will be able to pay. That's in the state law. But the state Supreme Court struck that down because what I just read you there is statute. Well, statute is subservient, obviously, to the law that is in our Constitution. The Constitution is controlling. And so what's in our Constitution, thanks to Marsy's law, in Article 1, Section 25, is this: guaranteeing victims, quote, the right to full and timely restitution in every case and from each offender for all losses suffered by the victim as a result of the criminal or delinquent conduct. That's pretty unambiguous. Full and timely restitution for all losses. So the portion of the North Dakota Century Code, the statute, which says that restitution ordered by the courts may not exceed an amount the defendant can or will be able to pay, the state Supreme Court ruled that that is now unconstitutional because Marsy's law says the victim has a right to full restitution for all losses. Quoting from the majority opinion written by Justice Jared Tufte, I quote, "In short, a district court may not consider a defendant's ability to pay in determining the amount of restitution awarded a victim." So there we are. Now, the problem with this is, and something I was surprised actually that the state Supreme Court didn't take up, is to consider this in the context of the 8th Amendment to the U.S. Constitution. Now, the 8th Amendment states, I quote, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Now, the clause that matters here is that clause regarding excessive fines. Now, I know what you may be thinking. Fines are a different thing than restitution, and you're right, except for that the U.S. Supreme Court, for the purposes of the Constitution, has held that restitution is the same as a fine. And so what we have here is essentially the state Supreme Court in North Dakota doing something that may well violate the 8th Amendment against cruel and unusual punishment, right? That's usually when we talk about the 8th Amendment, that's usually what we say. That's the cruel and unusual punishment amendment. Now, I think, personally, that it is cruel and unusual for the courts to saddle a defendant, even understanding that somebody like this woman, Melinda Strom, is not a sympathetic figure. Believe me, I realize it. She stole almost $700,000 from her employers. She was convicted of it. She's guilty of that. That's not in dispute. I'm not making excuses for this woman for doing that. That's a terrible thing to do. What I don't understand, though, is why we would think that it's okay for the courts to levy a fine, right? Because, again, that's what the Supreme Court, U.S. Supreme Court, is going to see this as, to levy a fine that the defendant cannot pay. I think it's reasonable in fact, there's a good reason why the North Dakota Century Code, previous to Marsy's law, said that judges can consider the defendant's ability to pay, right? Because it would be cruel for somebody who committed a crime to saddle them with an unpayable debt that they have to drag around then for the rest of their lives. Now, some people will say, they'll be unsympathetic to this, and they'll say, well, she shouldn't have committed the crime then. She shouldn't have stolen the money then. And I can understand that. But I like to think that as a country, we're moving away from that sort of throw the book at them approach to criminal justice. While certainly victims should be made whole to the greatest degree possible, the key word there is possible. How can you get a restitution level? How can you get restitution anyway? I mean, maybe we're all going to feel good, and we'll say, okay, well, Melinda Strom, in this case, has to pay the full $690,000, and it doesn't matter if she'll never be able to pay it. What do we get out of that? Do we all just feel good about that? We just, oh boy, we really stuck it to Melinda Strom? It doesn't make the victim any more whole, right? She's going to pay what she can pay regardless. So what do we get out of that? I think this is where the 8th Amendment comes in. This is why the 8th Amendment is important. We're going to say, listen, you can't just saddle somebody with a lifetime of, Melinda Strom's got to have a life. She's not going to spend the rest of her life in prison, right? Melinda Strom is going to be out in the world trying to live a life. If she has an unpayable level of debt on her back because of something that the court assigned to her, and granted the court assigned it to her because of her own criminal actions, but if she's going to live the rest of her life like that, how is she going to live? And is she not going to be more likely maybe to commit more crimes? If she can't live a life, if she's been made incapable by the justice that came out of the court system, if she's incapable of living a normal life? Again, that's why the Eighth Amendment is important, to make sure that these things are not arbitrary, to make sure that these things are not capricious. Now, the Eighth Amendment has not actually been incorporated to the states yet. There's another U.S. Supreme Court case that's probably likely to do that by the end of this. I realize that it's a risky thing to ever guess what the outcome's going to be from a Supreme Court case, but I think we could pretty fairly say that eventually the Supreme Court's going to get around to incorporating the Eighth Amendment to the states, and when it does, Marsy's law, I think, is going to have a problem. Which brings me full circle back to the problem with initiating policy like Marsy's law through ballot measures in the first place. Voters, I don't think, are able. Marsy's law is a complicated piece of policy. It's a lengthy piece of policy. What's more, it's constitutional policy, which means that its consequences, its ramifications are complex. They're not simple. And the idea that voters could consider all this, could consider what, Section N of the 25th section of Article 1 of the Constitution as amended by Marsy's law, what the implications for it might be in an embezzlement case in the context of the U.S. Constitution's Eighth Amendment, voters are really going to suss all that out? Voters are really going to understand all that nuance? Now, what defenders of the initiated measure process will say here is, well, you're just saying that voters are stupid. You don't believe in the will. You're just some elitist. You're some good old boy who doesn't want the will of the people, who doesn't want the common man to have a say. And what I'm saying is voters are not stupid, but they are too busy to consider something like this at the ballot box. I'd be willing to wager that the most the average voter in the 2016 cycle knew about Marsy's law is what they heard about Kelsey Grammer say about it in a television ad that was paid for by that California billionaire who bankrolled the whole mess. These issues are complicated, and they deserve more scrutiny and more process than the initiated measure process provides. And Marsy's law continues to be a shining example of why we ought not legislate that way. Now, another issue that I want to bring up is related to law enforcement reserve officers. Now, this is pretty remarkable. It is from another state Supreme Court ruling. State v. And I'm going to struggle with this last name. I think it's Ngale, Ngale. I apologize if I'm getting that wrong. But it deals with a reserve officer in Cass County who ordered a chemical test for somebody, I think it was a DUI case, despite the fact that they were not a licensed officer. Now, the court found that the reserve officer was exempt by law from needing to be licensed because, indeed, Section 12-63-03 of the North Dakota Century Code allows auxiliary law enforcement personnel who can operate as an adjunct to the police or sheriff's department and can carry a firearm and can make arrests. Which starts to make you wonder if law enforcement officers can have these reserve officers who don't have to go through the same sort of certification and training that law enforcement officers, normal, run-of-the-mill law enforcement officers have to. But yet they could still make arrests and they could still carry a weapon, which implies that, if they're carrying the weapon, and then implies that we would expect that in an appropriate circumstance, they would use that weapon. Well, then why do we have training or certification for any law enforcement officers? This looks like a pretty big hole that was blown open by, A, our existing law, and B, the state Supreme Court that is hopefully going to be addressed this legislative session. There is some legislation, HB 1459, introduced by State Representative Mary Johnson. She's a Republican from Fargo. And it would still allow reserve officers, but they wouldn't be allowed to make arrests. And they wouldn't be allowed to carry weapons. Now, this to me makes sense. Carrying a weapon and being able to make arrests, those are the two powers that law enforcement have. I mean, that's what cops do. I mean, if we want to get super simplistic about it, what are the two things that cops can do for you? Well, they can either use force against you, right? They're authorized to do that in appropriate circumstances, or they can arrest you, right? So if a law enforcement officer sees you and he or she thinks you're breaking the law, they can arrest you. And in circumstances warranted, they can use force against you. They can even kill you with justification. Again, if it's justified. And so what we're saying here under the status quo is that people who do not have to be certified and do not have to be trained, now they can be, and I think some departments do, provide their reserve officers with training, but they don't have to be. And to me, that's the problem. If we're going to allow them to wield these powers, why would we not require them to be trained and certified? That seems like an important thing. HB 1459, that's an important piece of legislation to watch. All right, so that's it for me ranting. We are now going to go to our interview with State Representative Karla Rose Hanson. Going to talk about her frankly, it's gun control legislation. It's gun seizure legislation. But we're going to talk with her about that starting straight ahead. This is Rob Port. I'm with State Representative Karla Rose Hanson. She's a Democrat from Fargo, and she is the sponsor of legislation that's really bipartisan legislation. It's regarding, I guess, creating a process through which firearms can be removed from the home of people who, for instance, may be suicidal, or for people who may be demonstrating some troubling or some violent behavior. And there's a term for it, and I had the press release in front of me, Karla, but it's a sort of protection order, right? I mean, maybe you can describe it better than me.
Sure. Yes, it is exactly a protection order. It's a new type of protection order, not unlike a domestic violence protection order, which is already in the civil section of our code. So what this is a civil process, not a criminal one, and it really the bill establishes what a public safety protection order would be in North Dakota. That's what we're calling it. Colloquially, this type of legislation is known as a red flag law.
Okay.
It's in place in about 13 other states, including Indiana. It's been in place in Indiana since 2004. And then in Florida, and it's been in place in Florida since the Parkland shooting. And that was really the impetus for it passing in Florida. So what a protection order, public safety protection order does is really enable people, either family members or law enforcement, to act before a warning sign escalates into a tragedy. We know that family members and law enforcement are often the first to see the signs that a person in crisis is a threat to themselves or others. So what this process does is enable them to petition a court to remove the guns temporarily from a dangerous situation. They fill out, they fill out an affidavit or they provide testimony, but it gets reviewed by a judge at every step. So there's always a strong due process, and the court is involved at every step.
And essentially what it is it's either, as I read the law, and certainly correct me if I'm wrong, but law enforcement can initiate this by basically seeking a warrant. They go and they give a sworn affidavit to the court stating why they believe the individual is dangerous and why they believe they may be in a possession of a firearm. And then they could get a warrant to go in and take the firearm. And then there's also a public safety order petition that could come from a family or household member where they could go in. They can essentially do the same thing, except, obviously they're not law enforcement and they can't just execute a search warrant. But in both instances, what then happens is once the firearm is seized, there's then subsequently a hearing where you got to show cause. And that's where you got to go and you got to demonstrate to the judge, we didn't just on a whim take this. This is a real thing. And I should add, there is a provision in the law, and I thought that this was very important because the minute I started reading this, Karla, I went looking for this. If somebody provides false reporting, it's a crime under this bill. It's a Class B misdemeanor. So if you start making things up about somebody, a family member that you got a grudge against or whatever, and you find out to be lying, there's some consequences for that, which I think is important.
Yeah. Yeah, we felt that was important too. So, and just to back up a little bit, so basically I led a group who put this together. It was really a coalition of North Dakotans who looked at all the similar legislation that was in these 13 other states, and we looked at what pieces we liked, how we thought it would fit in to North Dakota law and just how we practice. And this coalition was made up of a couple of police chiefs, sheriff's representatives, prosecutors, advocates for domestic violence prevention and also suicide prevention. There's school safety advocates. So we had a really broad coalition of people who really created the language that is in the bill today. And just to clarify the process a little bit.
Okay, sure.
You kind of talked about that. Yeah. So you are exactly right that there is one path for families and there is one path for law enforcement. So you can kind of think of a flow chart, I guess you can say. It's hard to describe verbally, but think of one path for law enforcement, one path for family members. There is a decision point. So they can each go to the court to request a public safety protection order. Normally, the hearing in both cases would be in 14 days when they make the request. So nothing is done until 14 days happens, unless the risk is imminent. So if the risk is imminent, then they can then go to the court to say this is an emergency. And then what they're doing is they're getting an emergency public safety protection order.
Okay.
In both cases, they have to show there is cause. Okay, they have to show a level of evidence for the full hearing, which is in 14 days, or if they're saying the risk is imminent and they need the emergency public safety protection order. So there's still a standard of evidence that the court would look at. So they're providing what they see or what they say, what the reason is, but the judge will look at that and decide if it rises to that level of evidence. Does that make sense?
It does. And I thank you for clearing that up, because I want, and to be clear, for people who want to read, it's HB 1537. You can look it up on the North Dakota Legislative website. I have a copy of it posted at sayanythingblog.com if you want to go that route as well. And certainly go take a look at the language for yourself, because it is a weighty piece of public policy. And so it's worth taking the time to read for yourself as well. Now here's one area where it concerned me. When I was reading the bill, I see a lot of things through the lens of the freedom of speech issue, because, Karla, I make a living out of saying and writing things that make people mad sometimes. I'm not trying to make people mad. I just do so organically. It's part of the job. And so I am very, very vested in my First Amendment rights, because I make a living from them, and they're important for everybody. The Second Amendment is also a civil right. And so what worries me, I was thinking about this in the context, because in the First Amendment arena, we have what's called prior restraint, which is where the government can't stop you from speaking because of what you might say. Right. So a lot of times, like for instance, we go back in the Sedition Act, or the Alien and Espionage Act around the time of World War I. In fact, the term, a lot of people use it in free speech debates. It's called shouting fire in a theater. That actually came from a United States Supreme Court case where the federal courts actually upheld the government's right to censor anti-war people from distributing anti-war flyers against World War I, because the idea was that they were going to cause harm or cause riots or disrupt the peace. Therefore, it was okay to restrain them from engaging in that speech. Well, the courts have struck that down now. We don't have prior restraint. You can't stop somebody from speaking, from exercising your First Amendment right because of what you might say, or from what the consequences of what you say or write might be. You can't do that. And so what worries me when I look at legislation like this is we're saying, okay, well, somebody might commit suicide, or somebody might do something dangerous or criminal with these guns. But where I get stuck is they haven't done it yet. And I don't mean that to sound awful, because suicide's an awful, awful thing. Nobody wants that to happen. Nobody wants a school shooting to happen. Nobody wants anything criminal to happen. But I worry about the idea of pre-crime, that we're going to go into a situation where we're taking away somebody's civil rights because of what they might do. Explain to me why I'm wrong.
I understand the point you're making. As with all of our rights that are protected by the Constitution, we always have to create a balance, right? Because sometimes there's conflicting rights, right? Mm-hmm. Or you can make an argument. So with this, we are always balancing the right of our public safety, our right to life, with our right to own a weapon.
Right.
And what we need to balance is those two rights that we have. And so it's just like privacy versus safety too, right? I mean, we always have that debate as well. So in the debate between public safety and the right to be safe, balanced with the right to own a weapon, one of the considerations is the potential of irreversible harm. So we do have the potential of irreversible harm when the evidence rises to the concern that someone might harm themselves or, for example, do a school shooting. You having your firearm removed temporarily until, we can show that there's not a cause for harm, that's not irreversible harm. So case law, this has been, obviously debated many times. It's been in a lot of states for a lot of years. Case law has affirmed the constitutionality of this type of legislation. And the Supreme Court has indicated that public safety regulations are not in conflict with the Second Amendment.
Has this specific policy been challenged to the Supreme Court, do you know?
So Hope v. State. So first of all, there's D.C. versus Heller, and that's where SCOTUS recognized that the Second Amendment, allows this public safety regulations not being in conflict with the Second Amendment. And Hope v. State was specific to this type of legislation in Connecticut, which was the very first state to pass this back in 1999. And so they affirmed it. They echoed the Supreme Court sentiment saying that you can have some regulatory measures adopted by legislatures, that balance the public safety need.
Yeah. But as I alluded to earlier, the Supreme Court also upheld restrictions on free speech on the idea that we needed them for the sake of public safety once upon a time. So the courts, I don't know that the courts are infallible on this either. I could give you a laundry list of Supreme Court rulings that I think both you and I would probably find abhorrent. Korematsu, for instance, upholding FDR's internment of Japanese Americans. So, I don't know. I struggle with this as a citizen. Let me ask you, when you put together the coalition to do this, were there any gun rights groups in that coalition, the NRA or shootings groups or anything like that?
The people involved are the people who would be using the law. So police, or just law enforcement in general. So a variety. So school resource officers who are on the front lines of things, police chiefs, people from sheriff's departments that deal with civil orders. So mostly we work with people who would be using this as a tool, and that's what they really wanted this to be an extra tool in the toolbox. And let's also say that a couple things about when this would be used. When someone is concerned that an individual is a danger to themselves or others, ideally those concerns are going to be resolved through the least restrictive means. They would not go to this point, right? Ideally, that person will first of all recognize that there's a problem. They'll be able to access behavioral health services in a timely way. If they own a firearm, they would lock it up. They would ask their friend or neighbor to store it for them. But not every situation can be handled that way. So in those rare cases when they can't be, then this public safety protection order could be additional tool in the toolbox, like I said. Now, I also want to say that sometimes I have called this a tool of last resort. So after all those other things have happened, this is a way for families to intervene after all other options have been exhausted. But it is actually a tool of second to last resort, because today there's another path that we do use when a person is a danger to themselves or others, and that's involuntary committal. So public safety protection orders are actually a less restrictive and, frankly, less expensive solution than an involuntary committal because, the police could do a 48-hour hold on you if, you are a person who's showing some concerns without even going to the judge. So this has strong due process at every point and prohibits prevents you from going down that path of staying in the state hospital, which, by the way, would end up resulting in you having restrictions from owning a firearm in the long term. Yeah. So there's three basic reasons a person would be prohibited from owning or possessing a firearm, both at the federal level and it's also in our state law. There's you're convicted of a felony, you're convicted of a domestic violence offense, or you've been adjudicated mentally ill or involuntary committal. And so this actually preserves your right to own a firearm because you're just getting a temporary timeout on the firearm instead of the actual person.
Yeah. And we should know, in my understanding from the law, and again, correct me if I'm wrong, that if a court puts an order in place, the order lasts for a year, and then I think 30
up to 1 year.
Up to 1 year. Okay. Doesn't have to be a year.
Yeah, it wouldn't have to be.
But then 30 days before the expiration, there's another hearing, and then the court can decide whether or not they want to continue the order in place or drop it. Is that correct?
That's correct. It's just an affirmative step saying, all right, everything good. Okay, we'll let it expire, according to the timeline. Or, well, no, there's still some concerns. We're maybe not stable yet. Or, another situation that's been raised is families who are concerned about a person with Alzheimer's. So, sometimes a person is too ill to realize that maybe they shouldn't have a weapon in hand. And so families will often raise that concern when they're seeking services there.
Yeah.
So
it's I mean, it's an interesting debate to have. And to be honest with you, I mean, I see some practical uses for this. I think situations with Alzheimer's, I think, I could certainly think of situations where this would be useful. I worry, as with all sorts of powers that we give the government, about getting carried away with them. And I also worry about setting up a situation where you don't necessarily have to actually commit a crime or do anything wrong before we take some of your rights away. I mean, I realize there's a due process concern, or there's a due process requirement here, but that's if there was anything that made me skeptical about Karla, and I think a lot of other people, it's that. And also, I wish maybe I could know that there were some gun rights groups that were involved in the process, in the coalition here. I know you said you limited it only to people who would apply the law, but I mean, our gun rights, again, it's a civil right, and it's important, and it would have been nice to know that some people like that were part of the coalition.
Well, I certainly think that a lot of our law enforcement officials are gun enthusiasts themselves, personally.
I don't
know. I do believe
their attitudes of some of them don't necessarily strike me as being pro-gun, but I think they're pro them having guns. I'm not sure about the rest of us. But that's my opinion. I'm sorry. I don't mean to interject that. But yeah, that's there. And, certainly, but it's going to be an interesting debate. And I don't know. I may even end up supporting this legislation. I don't know. But right now I'm a little skeptical. But I appreciate you coming on, making time for me to run down the bill. Anything else to add before we close out?
Really, I mean, my main points are that, it's a civil process, not a criminal process. There's strong due process at every stage. And the big benefit is that we really hope to save some lives, especially around suicide, because we actually in 2017 had an all-time high of firearm deaths in North Dakota.
Do you think that's because of the presence of firearms?
93 were suicides.
Yeah. Do you think because of the presence of firearms, or is it just, I mean, if somebody's going to kill themselves, I feel like they're going to do it whether they have a gun or not.
So actually research shows that that's not quite true. So I think we do have a variety of reasons why our suicide rate is high. I mean, it's high among our youth, it's high among veterans, it's high among farmers. So obviously there's a variety of factors that go into each of those different populations. But really research shows that if you put some time and distance between you and lethal means, you're less likely to actually die by suicide. And so perhaps if you're a person who attempts with cutting or pits, you're actually highly likely to survive and then go on to get treatment and live a healthy, long life. And so putting some time and distance between a person who has suicidal ideations and lethal means actually can really significantly save lives.
Karla, thanks for your time.
Anytime. Happy to do it.
That's it for today's episode of the Plain Talk Podcast. Remember, new episodes every weekday, Monday through Friday. If you want to subscribe to the podcast, you could do that, sayanythingblog.com. If you look at the top menu, there's a section there called the Plain Talk Podcast. You can go there. We have links to subscribe on Spotify, You got a link to subscribe with an RSS feed. So if you want to plug that into your favorite podcasting app or service, we're still working on getting the podcast listed in Google and iTunes. So stay tuned for that. If you see any problems, you have any problems with the podcast, the way it sounds, using accessing the podcast through your favorite podcasting service, email me, rob@sayanythingblog.com. Or if you have any feedback on the show, you can use that email as well. Or if you just want to say hi, do that as well. I like it when people say hi. That's it for today. Thanks for listening. We'll talk again.